stay on with us. We are getting some latest updates. In fact, that opening for the CBI, the Solicitor General Tushar Mehta has said that it is a very horrific case involving a child aged 15 years. Charges were framed during trial on two broad offences, that is section 376 of IPC and section 5/6 of the POCSO Act. Conviction is on 2 counts. Conviction order is referred to by the Solicitor General. So this is the latest that is coming in, Sambhav. We have Tushar Mehta starting off for the CBI. He's stating that it's obviously a very horrific case. It involves a minor, a child, 15 years only, and there are 2 very important broad offences that have been filed against the convict.
Well, absolutely, it was very much expected, these kind of arguments in the Supreme Court, and as the hearing begins, Solicitor General Tushar Mehta for Central Bureau of Investigation putting forth his argument as we speak, and here the hearing in this particular case has begun, and the hearing is going on before the 3-judge bench of the Supreme Court headed by the Chief Justice of India, Surya Kant. And here, if we talk about the important arguments made by Solicitor General Tushar Mehta, S.G. Tushar Mehta appearing for CBI is telling the court that this is a very horrific case involving 15-year-old child. And
in fact, Sambhav, stay on with us. We are getting some latest updates. Now, Solicitor General Tushar Mehta has also stated that there is a trial being conducted. There was a finding that the child was less than 16 years and the appeal is pending in that trial as well. To that, the the Chief Justice of India has asked him a question if this is against this conviction, and the Solicitor General has said yes, he's replied an affirmative. He also added that at the time of sentencing, the trial court convicted under section 376(2), which was a statute book on date of offence, and this is an aggravated form of rape. Someone that has a dominant position.
I request to just zoom in the frame from the Supreme Court, and here the victim herself is present inside the top court of the country, and you can see the visuals from inside the Supreme Court as the hearing begins. And the crucial hearing, very important hearing in the Unnao rape case is going on, and victim herself is present. The rape survivor, I must say, is present inside the Supreme Court, and she is trying to enter the high security, probably yes, and she is trying to enter the gate from, inside the Supreme Court, and the court number 1 is just 50 meters away from where she is. And if we talk about the arguments being made by the Solicitor General Tushar Mehta, but prior to it, what is more important is CJI, the Chief Justice of India, Surya Kant, has observed that even when the victim is not a minor, aggravated rape attacks minimum sentence of 10 years and extendable up to 20 years.
Right.
And
right. In fact, Sambhav, stay on with us. We are also joined by a lot of people on the broadcast. Tahira Hassan, a women's rights activist, is with us. Advocate Ashwini Dubey, AOR of the Supreme Court, is also there. Let me first go across to Tahira Hassan. Ma'am, when we are looking at this entire incident, obviously there's a lot of outrage, and hence it's very important to track what the Supreme Court actually observes regarding the CBI plea that has been filed.
Yes, I am looking at the Supreme Court. I'm optimistic also, you can say, and let's see what the Supreme Court verdict is going to come. But thing is this, that what is more disturbing, that accused and convicted, they get bail. Whether it is a Sengar, whether it is a Ram Rahim, whether it is Asa Ram, and whether it's accused, convicted people in the rape and murder case of Bilkis Bano, and they are just get the bail, and they are free, scot free, you know, and the jailer said that because of the good conduct. I don't understand that rapist has also a good conduct, the who has violated women body. How can you say that he has a good conduct on that basis he has acquitted? So it is a really very shameful, and it is going to weaken the deterrence. I think this thing Supreme Court will see. I'm sure that the emphasis must be on that also, because we constantly are saying that we have a very stringent laws in our hand after the Nirbhaya Justice Verma Committee constitutes.
Right. In fact, also, I think there is a connection issue over there, but let me go across to Advocate Ashwini Dubey as well, who is also with us on the broadcast. Sir, when you are looking at this entire issue, we obviously spoke about the issues that the Delhi High Court judgment has listed. They have observed quite many things. They have, but let's talk about Section 5 of POCSO, which is also being challenged by the CBI in this case, sir.
Yes, see, the conviction is on 2 counts. One was under Section 376 and another was 5 and 6 of POCSO Act. So it is no doubt that the Kuldeep Sengar has been convicted by the trial court. He has been found guilty in this matter. Now I see as a defense lawyer and a student of law in 2 counts. One, 7.5 years of punishment as noted by the High Court while suspending the sentence he has undergone. Incarceration he has been for 7.5 years. Number 2, the appeal is pending because final decision has to be taken in a criminal appeal by the High Court. So that was the interim measure considering on 2 aspects. One, that the 7.5 years, that is around 8 years, he has already been incarceration, number 1. And number 2, the definition of public servant as has been invoked by the trial court was contrary to the basic law, which is not found given the case. Now, even if Supreme Court today reverse back the order of the High Court that the granting him interim bail or interim release, then in that eventuality appeal has to be heard. And what would happen tomorrow, that would depend what the completely wisdom of the court and also what evidences court consider, which has been found proved by the trial court, and what the High Court does not consider. That would be completely in a, we cannot say, because saying something will be a presumption, which will be only a speculation. Now, one thing important herein is the gravity of offense, of course, has been proved by the trial court, and that requires the severe punishment. Now, giving bail is complete wisdom, judicial discretion, and the provisions gives immunity to the judge to pass that order. And going to the appeal either by the prosecuting agency or by the victim is also the right has been given the criminal jurisprudence, criminal law.
Right, right. In fact, let me come back to you, sir. We have some more inputs regarding this hearing that is currently taking place over there. The Solicitor General, in fact, stated that the court has also mentioned that crimes like this should face biological, the punishment should be till biological life. Over there, then the Solicitor General is also talking about paragraph 25 of an impunged order, where he stated that life sentence is the minimum in the facts of the case. Then we have the CJI who's stating, who's asking the Solicitor General if this argument that the concept of public servant is alien when the victim is a minor, and to that Tushar Mehta has replied in the affirmative. He stated that absolutely POCSO Act offences can be broadly classified into 2 categories. First is the penetrative sexual assault is an offence, and 4 actually provides for punishment. 2019 there has been an amendment that it was not less than 10 years, maximum life in certain sentences. That's aggravated form. And the categories are that if a person is not in a dominant position, then it is considered aggravated form. So they are currently in fact debating that POCSO Act section that has been questioned even in the Delhi High Court order. Let me go across in fact also to Mr. Singh, who is with us on the broadcast. Mr. Singh, when we look at section 5 that the court is currently discussing as well, what do you make of it, because there are arguments to and for both the parties?
Look, Shivani, I mean, as you rightly said, solicitor is arguing for two things: penetrative sexual offense and aggravated penetrative sexual offense. But before that, he is also going into the domain that the victim, the accused, was in a dominant position over the victim. So far as Section 5 is concerned, he is absolutely clear. I mean, the CBI is absolutely clear. I do not know what CBI has taken the stand in the High Court, but as of now, what I see in Supreme Court is absolutely clear that the solicitor on behalf of the CBI is absolutely clear that this offense, so far as POCSO Act is concerned, is squarely covered by it. So releasing him for a period of 7 years, since he has already undergone, and thereby giving him a bail is something which is not very prudent, a judicial reasoning. So now the solicitor is absolutely firing with all ballistics, what I am reading in the bar and bench also, that he is pitching for not less than a sentence which covers the entire life of the accused. And that is what a judicial sense is also all about, that he should be given a sentence which covers his entire biological life. And I'm sure the CBI is heading towards that very direction only. Yes, please.
Right. In fact, we are also getting to know that, the Chief Justice of India is asking Tushar Mehta if the public servant need not be strictly as per law, but has to be seen as a person who has dominance in the society. So he's actually seeking clarification from the Solicitor General's submission to that. Tushar Mehta is saying that yes, the public servant concept applies to this person who has dominance in society as well. In fact, also joining us on the broadcast is Mr. L.N. Rao, former DCP. Thank you so much, sir, for joining us on the broadcast. Sir, a very important case currently ongoing in the Supreme Court. It's hearing the CBI's plea, and we are talking and discussing Section 5 of the POCSO Act, which the court also...
victims. So now we have to wait and watch what is the final verdict of the Honorable Supreme Court comes in this case. And I think that scrutiny of the High Court order definitely is to be done by the Honorable Supreme Court of India.
Absolutely. In fact, Mr. Dubey, if I can come to you, when they are discussing this, they are talking about how, the MLA thing comes into the picture, because they have been stating that, since the Solicitor General was saying that he was a very powerful MLA when this crime was being done, and hence he had dominance over the victim in this case. And the CJI is saying that the court also did not want to grant him protection of not being a public servant. All these arguments that are coming to the force, could you help our viewers understand what is the sequence of events that they are discussing?
Section 5, as you said, that the Section 5 of Protection of Children from Sexual Offences defines the aggravated penetrative sexual offence. Means by a person in authority or public servant. So far as coming in the authority is concerned, of course, being an MLA of that area, he was in a powerful position. So, and then this, one of the definition of this section is also that a police officer, a member of the armed or security forces, or a public servant. Then the second limb is by staff institutions, which applies to any one of the limb is by staff institutions, which applies to any one of the management or staff of a jail, remand home, protection home, observation home, hospital, educational institution where the child is an inmate or a student. Then a gang assault also comes there when the offense is committed by one or more persons in a group in furtherance of a common intention. Causing grievous hurt or severe injury, that is also there. Causing pregnancy or life threatening. So these are the limbs basically. So coming to the first definition, if we see the by person in authority or a public servant, So here his case squarely lies, and as the trial court has reached to the conclusion, that is right. But the High Court has taken one view. High Court says, so far as the definition of public servant in section 21 of the Indian Penal Code is concerned, that is only related to the public officers, public servants who discharge public duties. So for the MP MLAs are concerned, they are not the public officers. And then if we see the definition of public servant which has been given in the Prevention of Corruption Act, that's altogether a different limb is there. Now, if Supreme Court today comes to the conclusion that MLA or MP, they are also the public servant within the framework of the legal position of the POCSO Act, then it will set a benchmark. If tomorrow somebody is in a dominant position, discharging public duties, is MP, MLA or on any other constitutional authority which is not specifically provided in the law, if commits this kind of offense, he will be considered to be public servant and punishment will also to be that effect. So let's see what the jurisprudence, what the interpretation comes from the Supreme Court. But so far as the punishment to the Kuldeep Sengar is concerned, because I have two things. The judicial wisdom of each court is different. High Court, in its judicial wisdom, has granted the temporary relief, temporary respite to Kuldeep Singh. If Supreme Court finds the High Court was not right, Supreme Court may set aside, have prima facie substance. Court may ask other bench to hear it, or Chief Justice of Delhi High Court to hear it, as in the trial was transferred from Unnao to Delhi. Let's see what happens tomorrow. It is completely on the speculation. But yes, new definition would come from the Supreme Court, which will set a benchmark and precedent. Over to you.
Right. In fact, the latest that we are getting to know from the Supreme Court hearing is that the Solicitor General has clearly stated that this person is guilty of offence of killing the family of the child, and hence they are requesting the Supreme Court to in fact stay the offence. This is the latest that's coming in. In fact, let me take that across to Tahira, who is with us on the broadcast. Ma'am, obviously this person has another case that has been registered against him. He is accused of murdering the family of the victim. He is facing 10 years in prison for that, and hence he is not out on bail, working like a free man after that Delhi High Court judgment. But when you look at such an offence, we know how influential he can be.
Yes, he is very powerful. He is influential, no doubt. And when such accused or convict walk out of the jail, then survivor not only face violence, but humiliation, never-ending legal battle. And this kind of, when they walk out of jail and get the bail after such a committing heinous crime, violating women's body and murdering the family members, this amplifies fear, discourage reporting. I salute the girl, survivor, who at least is standing strongly. Otherwise, this discourage reporting and normalize impunity. I'm sure the Supreme Court always stood with us, with the women in the distress. This time again, I think, highest court of the land will stand with the survivor, and this will be again a victory for the women, and not only women, and all who stand for the justice, who have trust in legal system, who have trust in our institution, and who believe that this largest democracy is run by the Constitution. So I'm very optimistic. Let's hope what is going to happen, but I'm sure about it.
Absolutely. In fact, let me take you.
But one thing more I'm saying.
Yes.
Petrarchy is deep-rooted, and they try to control the sexuality of the women. They make the guideline, control the women, free movement also, make them commodity, a property, and only they even punish the woman in the name of honor and morality. It's not, we are not in anarchy.
Yeah. In fact, let me take our viewers through a summary of what all